Well, good morning. My name is Paul Goldstein. I'm delighted to welcome you to this morning's session on intermediate or copyright liability of intermediaries, what China and the United States can learn from each other. As it turns out, since we have some Canadian connections here as well, perhaps Canada will learn from the China-US experience and vice versa. Of all the revolutions that have been triggered by the internet, none is greater than the revolution in legal rules applied to the activities of so-called copyright intermediaries. The revolution in legal rules aimed at regulating the behavior of intermediaries, internet service providers essentially, in their dealings with copyrighted materials. This revolution has brought new players to the copyright policy table. No one would have thought a half-century ago when the US copyright law was being passed, no one would have thought that telephone companies would be at the table in Geneva when the WIPO internet treaties were being discussed. Telephone companies never came close to the copyright policy table before, and they turned out to be a very important voice. New legal mechanisms have been created. No one, I think, in 1976 would have predicted that a mechanism like the safe harbors of the Digital Millennium Copyright Act in the US would have been introduced into the copyright law, yet it has become a central norm in copyright laws around the world. No one would have predicted the conflict between copyright's creativity and technological innovation that arose as a result of the internet, with the continuing debate being, can we have acceptable levels of investment in film, music, literature, and at the same time not suppress the great innovation that we have had in the technologies of the internet. The one thing that is not new is all of these pressures on the legal system, great as they are a prelude to an old phenomenon of copyright owners and their eventual technological distributors sitting down and hammering out arrangements between themselves so that copyrighted works can most effectively get to their consumers. This has happened every time copyright has encountered a new technology, every time in its history, as private parties bargain in the shadow of the legal rules that we'll be talking about this morning. So that is the one thing that is not new, and it is a comfort that we can look to private ordering of allocation of interest as between producers and their distributors. We have a wonderful panel to address these issues this morning. I'm going to introduce them briefly. You have in your materials the more elaborate statement of their biographies. Josepina D'Agostino is an associate professor of law at the Osgoode Hall Law Faculty in Toronto, Canada. She's also founder and director of IP Osgoode, Osgoode's intellectual property law and technology program. She will talk about ISP copyright liability in Canada and perhaps have some lessons for us on the US-China question. Jerry Liu will speak on ISP copyright liability in China. Jerry is to Josephina's left, and I'll be just going down the panel in that order. Jerry is an assistant professor of law, just finished his first year at the University of New Hampshire School of Law, widely published on copyright issues, and I'm proud to say my doctoral student here at Stanford. To Jerry's left is another Stanford Law graduate, Fred von Lohman, who will speak about intermediary liability and its impact on technological innovation. Fred is the legal director for copyright at Google, and before joining Google, he was an attorney with a very important public interest organization based here in San Francisco, the Electronic Frontier Foundation. On Fred's left, Wong Chien, who will speak on the influence of the U.S. DMCA, the safe harbor provisions on ISP liability in China. Professor Wong is a professor at the East China University of Political Science and Law. He received his doctorate at Peking University and also a master's degree from Toronto. To his left is Yuen Tuen, who will talk about fighting online piracy. Appropriately, he is the Director of IP Policy and Enforcement of Microsoft China, where he is based in Beijing. He has had a variety of content owner representations. He worked before that for General Electric, NBC, Universal, a major entertainment conglomerate. Parker Zhang, to his left, is the Director of Patent Strategy at Baidu, where his portfolio is somewhat broader. He leads a team responsible for Baidu's IP strategy, including portfolio development, licensing standards, and IP rights. Our speakers will each speak for 10 minutes. If everybody, and now I, behave ourselves, that will leave us plenty of time for questions and answers, so please do make mental or written notes of questions you have as our speakers go on. Pina, you're first.
Okay, good morning, everyone. I want to really thank the organizers, May and her team, and the sponsors. It's an honor for me to be here, an honor especially to be on this panel chaired by Professor Goldstein, and I'm a big fan of his work. And an honor also for me to really get to address a bit of Canada's framework on ISP liability. So just picture I'll be flying the Canadian flag for the next 10 minutes. Now, what I'd like to do is to first give you a brief backdrop against which our ISP liability framework is set, then talk a bit about the common law framework, so our case law on point, the new amendments that were introduced just last year, so the Copyright Modernization Act, which came into force just past November, so very recent stuff. Of course, unanswered questions, and then some conclusions. So in Canada, anything that we seem to do is set against the backdrop of this word balance. So we've had this big Supreme Court of Canada case back in 2002, the Theberge case, and this alludes to what Professor Goldstein was talking about, things that are not new, but they've come to the fore very much in the early 2000s in Canada in the debate about copyright. Whose interests should be served? And really what we need to do is to balance these interests, so the owners, the authors on the one hand, against the public interest. So the public is very much scrutinized against anything we do, so be they judicial cases or in the copyright amendments that we've seen. So keep in mind this word balance. So Canada is all about balance. Now, at the same time, in the case law and ISP liability, we've had also an acknowledgement that the internet is one of the greatest innovations of all time, and we need to be mindful of this and not as to have a chilling effect on this. So we had an early case. This is the SOCAN case. So SOCAN sued the internet providers, so it's a music copyright collective, suing for the customers that were downloading music and saying, we need a cut on the royalties. Basically, the court said, not so fast. An intermediary is acting in a capacity as a mere data conduit and providing services necessary for others, and there's no liability here. And they looked really to two main grounds, so telecommunication and then also the authorization doctrine. So I'll just go through briefly each of those two. Now, Section 3 in the Copyright Act is really the section that hangs all the owner's rights. So this is the bundle of rights, the exclusive rights of the owner. So the reproduction right being the first one, and then telecommunication is one of them. So these are the exclusive rights that only the owner could do. But in this case, there was an exemption in the Copyright Act, and this is called the common carrier exemption, where it says that a person that simply provides the means of a telecommunication necessary for others to communicate does not engage in telecommunication. So therefore, this is an exception and not a violation of the communication right, the telecommunication right that only the owner can do. So some tools already in our system, even before the amendments that we had in place, to shelter ISPs from liability. Authorization, another doctrine that we had that was under scrutiny both in the case that I mentioned, the SOCAN case, and then also CCH, which is known commonly as the fair dealing case in Canada, and I've written lots about this. This case was also known for authorization in that you had the great library of the Law Society of Upper Canada that had photocopying machines in the room, and the court said just because the photocopying machines are in the room doesn't mean the great library is authorizing infringement by its patrons. So just because you have the equipment that could be used to infringe copyright doesn't mean that you're actually infringing copyright. So what you need to do is you must approve, sanction, or exercise control over an act. You need to do something more to be caught under copyright. So again, another part to shelter ISPs from liability. Now, the big amendments that came to play, so this is just last year, in many ways what these did for Canada is that it codified the existing practices that we had, both on the common law spectrum and also added new ones. And really what it did is that it added this new thing called the notice and notice system. And I think this is something that is really uniquely Canadian and very much different from what you have here in the US and also in China. And I think that would make a good topic for comparative studies. So this Copyright Modernization Act, what it did was it really, the big lingo in Canada was that it ushered Canada into the digital age. Finally, we're getting it through this act. And I have to say, it took many years to get to this 2012 Copyright Modernization Act. So there are exemptions that were ushered in on primary infringement, and then this new provision on enablement, and then, of course, notice and notice. So I'll just go through the main exemptions. So there was one on telecommunication and reproduction, caching and hosting. These are all exemptions now for ISPs. The new enablement clause, when a person by means of the internet provides a service primarily to enable acts of an infringement, then there may be liability. So if you're a general search engine, there should be no liability. But if you're a BitTorrent and you're primarily inexistent to enable acts of infringement, then you may be caught. So here, the actual provision delineates a series of factors that the court might be mindful of to ascertain liability. So this is a new provision that we had, and in many ways it codifies what we already had in place in the common law. So notice and notice. So this is the big one. So notice and notice is notice and takedown. What it means is basically an owner finds something that they deem to be infringing, and they send a notice to the ISP and say, look, your customer has infringing content. At that point, the ISP sends a notice to its subscriber, to its customer, saying there is a third party, the owner, that's alleging that you're infringing. So at that point, they've already discharged their obligation because they've provided the notice. They retain the record of that transaction of what the subscriber was doing, and they're fine. At that point, it's the alleged infringer, so the customer, that then decides whether they want to pull down the content or whether they're just going to leave it up there. So in terms of the ISP, as long as they forward that notice that they got from the owner, then there should be no liability. They don't need to take down the work. So that's different from what you have with notice and takedown. So all they need to do is provide the notice. If they fail to perform that duty, then there can be liability, and that's capped from $5,000 to $10,000. So what this really does is it puts, and this goes back to one thing that Professor Goldstein mentioned, private ordering. It really puts it on the owner vis-a-vis the customer to enforce their rights. So whether the owner wants to pursue a court of action, then that's up to them. But the ISP is doing so is removed from liability. Notice and takedown, I'm not going to go through it too much because I'm sure we'll hear from other experts on this, but the main difference being that unlike in Canada, the material is deemed to be infringing upon notice given and then subject to removal. So notice and notice in Canada, I think on the whole was well received, especially from the ISP community. There's always for and against. You can never make anyone happy in law reform. But on the whole, the ISPs basically said that this system is better rather than the more extreme measures such as notice and takedown. And it's a uniquely Canadian approach. And this was by Shaw Communications' testimony before Parliament on Bill C-11, which is what turned out to be the Copyright Modernization Act. On the other hand, against were more the owners and the authors saying that this is not good enough for us. You're basically saddling us with the responsibility now to enforce our rights in the courts. Not fair. Generally, I would say that when you look at the ISP liability framework, it really has been a made-in-Canada approach. There are still unanswered questions. I think the first two up there will leave it to the academics and the litigators to figure out. But the last one really is going back to the notion of balance. And when you look at the different models to govern this issue, does Canada get it right with notice and notice? So what we can learn from Canada is really that what we've done is to look around, we've taken our time, we've taken a wait-and-see approach, we looked what was out there, notice and takedown, did not like that too much, and we wanted to strike a balance where we still also ensured that the public had access to the works, as opposed to erring on the side of taking things down. And it really, what it did is that it codified existing practices. So in conclusion, ISPs are here to stay, and I would say that it's pretty clear now that they need to be doing something more to attract liability in Canada. And of course, we have this notice and notice system. So with that, sheshe, and thank you very much.
Thank you very much for this wonderful opportunity. Let me start my presentation with three basic questions. The first question is, does Chinese copyright law include any safe harbors for ISP? You may say, of course, just look at the law. But if we define safe harbors as legal exemptions for ISPs who will otherwise be liable for copyright infringement, then the answer is not really clear. That leads to my second question. do the safe harbors provide any extra protection for ISPs? And I will show the answer is probably no. The third question is, do ISPs have any incentive to comply with the requirement under the safe harbors? This is closely related to the second question. If safe harbors do not provide any additional protection, then ISPs have little incentive to comply with those requirements. So keep these three questions in mind. Let me quickly go through some of the leading ISP cases in China. First, search engine. Many search engines in China offer specialized music services that provide hyperlinks to third-party music files on third-party websites. The litigation around search engines involves three phases. In first-generation cases, Chinese court thought deep link can constitute direct infringement. In the second-generation cases, Chinese court went to another extreme. They believed safe harbors would never be liable for copyright infringement unless they failed to act upon notification from copyright owners. Eventually, Chinese courts arrived at a more nuanced position in the third-generation cases. On the one hand, they found no direct infringement by linking. But on the other hand, providing links to infringing content might be held liable for indirect infringement if the ISP has actual or constructual knowledge. The US influences are quite obvious in those cases. The first-generation cases are influenced by 1995 white paper. The second and third-generation cases are influenced by the Netcom case and the Perfect 10 versus Google and its server test. It's fair to say the US experience has kick-started the internet copyright jurisprudence in China. But the wholesale borrowing become a little bit more problematic in the later P2P cases. In one of the leading P2P cases in China, the court quickly found constructive knowledge because of several facts. First, there is a central indexing server. Second, the defendant is a specialized entertainment website. Third, feature movies are made available online free of charge. And most importantly, there is general knowledge that copyright infringement is prevalent on the website. In another case, Chinese court went a step further and found inducement infringement because the defendant has a lot of advertisement that attract consumers to its movie television channel, and the defendant didn't take any preventive measures. Again, you can see a lot of US influences over here, which actually created several unexpected problems. First, so-called substantial name-infringing use. We borrowed from Napster, from Sony. We all know Justice Stevens imported the defense from patent law, US patent law. But there's no equivalent foundation under Chinese patent law. So Chinese courts sometimes apply the defense in a very peculiar way. For example, recall in Napster, substantial name-infringing use is can negate any imputation of constructive knowledge. But in Chinese cases, substantial name-infringing use become a rebuttal to actual knowledge. But inducement infringement is even more problematic. Recalled in Grosker case, the US court held the defendant induced downloading because downloading can constitute copyright infringement in the US law. But under Chinese law, personal use for study, for enjoyment, is clearly fair use. So if you want to improve inducement in China, you have to prove inducement of uploading. But just think about it. It's much more difficult to prove an advertisement about a large collection of pirating movie and the music is actually to induce uploading. Let's move on to UGC cases, user-generated content, video hosting websites. Interestingly, those UGC cases started to depart from the US position. So Chinese courts frequently found contributor infringement, an outcome totally opposite to the Viacom versus YouTube and to the UMG versus Shelter cases. There are several possible reasons. First, as required by Chinese censorship law, almost all UGC websites employ a team to pre-approve all video uploaded. So blockbuster movies must be apparent to those examiners. Second, many Chinese UGC websites have separate channels for original, for movie television. It applies. Those websites know movie and the television shows uploaded by users are not original. And third, the general knowledge that copyright infringement is prevalent on the website is sufficient for contributor infringement in China. Apparently, US courts think otherwise. But most importantly, ISP safe harbor never played any major role in any of those cases. In order to see why, just let us focus on one of those safe harbors for hosting, like UGC website. There are 5 conditions, and let's focus on just 3. First, the ISP does not modify the content uploaded. That means if it does, it might be liable for direct infringement as editor or publisher. Second, the ISP does not know and has no reason to know the infringing content. The question here is whether the knowledge prong under contributor infringement is equal to the red flag standard under safe harbor. And apparently most Chinese courts think so. Then, if an ISP is liable for contributor infringement, the safe harbor will automatically become unavailable. Third, the ISP does not obtain any direct economic benefit from the infringing content. This is actually one of the 2 prongs for vicarious liability. But the condition fails to incorporate another condition, which is the ability and the right to control. But more importantly, unlike US law, Chinese copyright law does not recognize vicarious liability outside of the narrow scope of employer-employee relationship. So the actual meaning of this condition becomes particularly elusive to Chinese courts. Let's look at another safe harbor, a safe harbor for information location tools, like search engines and sometimes P2P services. So it reads, the ISP is not liable for any damages if it promptly removes the link to the infringing content upon reception of notification. Notwithstanding, it shall assume joint several liability if it knows or shall know the infringement. So this is actually not a limitation of liability. This is a restatement of liability. So no wonder many Chinese courts never really apply any safe harbor in search engine and P2P cases. So my conclusion is, under Chinese law, if an ISP is liable for copyright infringement, the safe harbor will become unavailable as well. If an ISP is not liable for copyright infringement, it does not have to worry about safe harbor. So there's a very limited incentive for ISPs and for Chinese courts to pay much attention to safe harbor at all. And in practice, the safe harbors create more confusion than solution in China. But you may ask, whether the safe harbor fare any better in the United States. This is a very important and interesting question that at least entail another 10 minutes, which I don't have. Thanks a lot.
Good morning, and thank you very much for joining us this morning to discuss this very interesting topic. I thank the conference organizers for the very kind invitation to speak to you this morning. I think our previous presenters have done a fantastic job setting up the issue that I want to spend my 10 minutes talking about. And that is the ways in which copyright policy, specifically copyright policy relating to intermediary liability, the topic of our panel today, is in essence becoming our innovation policy. Traditionally, countries have thought about copyright law as a law about authors' rights, about creating adequate incentives for the creative industries, music, movies, television, software, publishing, but only very recently, and I would argue even now not enough, countries are recognizing that copyright law actually dictates what kind of new technologies are being developed today. It has become an important part of the general economic policy for technology innovation that has nothing to do with movies and music and traditional entertainment and other copyrighted goods. So it is very interesting having heard now these very contrasting presentations about the regime for intermediary copyright liability in Canada versus the one in China to decide or to learn as time goes on which innovations are encouraged by one set of rules and which innovation is discouraged by a different set of rules. So I am not going to speak in detail about the US system. I think you'll probably hear plenty about it. Many of you, no doubt, already know an enormous amount about it. But I will just say this. Without our DMCA safe harbors, the safe harbors that we have for our online service providers, there would be no Google. There would also, I would submit, be no eBay, there would be no Amazon, there would be no Yahoo. There would, in effect, be none of the largest companies that have defined innovation on the internet in the past 10 years. I do not think, in other words, I do not think that the kinds of innovation we have seen have been an accident. They have been a direct expression of the copyright rules that we have adopted in our various countries. So let me just say the reason for this is because modern digital technologies depend upon reproducing and transmitting content. And copyright law has expanded its scope over the last 100 years to include a very broad array of content. So today, every email that is written, every Facebook post, every YouTube video that is uploaded, all of these things are subject of copyright protection. And that, of course, means that every piece of technology that is capable of being used for those purposes suddenly has to be considered part of the copyright system. This was simply not the case 50 years ago. I would say it was probably not the case even 30 years ago. But certainly today, when every new digital technology is going to be making copies, transmitting copies, and copyright law covers essentially everything that can be fixed in a tangible medium of expression, now copyright law and technology policy are one area to discuss. So let me say then what we need intermediary copyright liability to do is we need that area of law to take innovation seriously. We need to ask of our intermediary copyright rules, will these rules encourage innovation? Will these rules create new jobs? Will these rules encourage investment in new technologies? It is not enough to simply ask, as I think so many have for the last 10 years, what can intermediary liability do to stop piracy? Of course, this is a valid question. One must take seriously the issue of getting the rules right so that the enforcement of copyright does not become impossible. But one must also ask of intermediary liability, is it encouraging investment in technology development? And that's a question that I think too often is left off the table in discussions about reforms or changes to intermediary liability. Let me just mention two ways in which this has already shaped the innovation that we all live with every day. Two examples that I hope will make this clear. First, consider the general purpose computer. The personal computer, hard drives, the entire technology that has defined the digital revolution of the last 30 years. Why is that technology legal? It is, of course, used for copyright infringement every day by millions of people somewhere in the world. Why have we permitted the existence of these computers when they can be used for infringement? Well, fortunately, copyright law, pretty much everywhere in the world, has decided that we will not hold general-purpose technology makers liable for every infringement committed by a user. That, in the United States, was the result of our Sony Betamax case in 1984, which gave us the doctrinal principle that so long as a technology is capable of substantial non-infringing uses, its maker will not be held responsible for infringing uses except in special circumstances such as inducement or actual knowledge. I'm pleased to hear that China has been adopting a similar principle. Without that principle, the creation of the technologies that make personal computers possible would have been impossible, or at least would have created enormous copyright liability. Another example that I think is very vivid in the United States is you look at the nature of the internet industry itself. It is, I would submit, no accident that the most successful companies, the most successful innovations that we have seen in the United States in the internet sector during the last 15 years all coincide with the safe harbors that our copyright laws have created for online service providers. We have a safe harbor that applies to linking, or what in the law we call information location tools. Of course, we also happen to have companies like Yahoo and Google and Microsoft's Bing. Many of the leading search engines were created in the United States and found their first success here. I would say that if there was not the clarity provided by the safe harbors, it would have been very difficult to imagine those companies receiving the kind of investment and encouragement that they have. Similarly, we have a safe harbor for hosting, for storing information on behalf of users, as our statute puts it. And of course, if you look at the companies like Facebook, like YouTube, like Flickr, the photo hosting service that Yahoo owns today, if you look at all of these platforms depend on hosting material on behalf of millions of users. To give you an idea of how successful and how popular this has been, today we have more than 72 hours of new video uploaded to YouTube each minute. That means basically every month there is more new video uploaded to YouTube than has ever been broadcast on television in the United States in history combined, each month on YouTube. So the question is, would these businesses exist if the platform providers were liable for every infringement committed? The important thing to notice about these technologies is they are not principally technologies of infringement. They are not pirate technologies. Whether you're talking about the general purpose computer, or whether you're talking about search engines, or whether you're talking about YouTube, each of these technologies, 99% or more of their use is perfectly legitimate, is not something that is damaging to copyright owners. Now, of course, the remaining 1% is certainly a problem that must be addressed. But intermediary copyright liability, I would submit the job of those rules, of those legal norms, is to encourage the development of technologies that are 99% good for society at large. So let me just end with two thoughts about the future of intermediary liability and what we should be thinking about, perhaps more than we have been. The first is, does our intermediary liability policy in copyright Does it leave room for things which have not been invented yet? Too often, when you have a debate about intermediary liability, the debate is about companies and products that we are all familiar with today. You ask questions, will this work for this search engine? Will this work for this video hosting platform? Will this work for this linking service? We must ask, will it work for tomorrow's technologies as well? And secondly, we must always keep in mind that many of the greatest new innovations come from the smallest companies. So we must ask ourselves when we look at intermediary liability, will these rules work for the smallest companies as well as for the largest? Because rules that perhaps Google can comply with may not have been rules that would have worked for YouTube in 2005 when it was just a handful of college students trying to invent the future of video. So I will leave you with those thoughts. Thank you very much. I look forward to questions.
Professor Wang?
Good morning, everybody. As we all know, that the United States has taken the lead in addressing the issue of copyright protection in the digital age. It is no surprise that the DMCA, as the pioneer legislation in this regard, has had a very strong influence on many countries' legislation, including China. The copyright regulation adopted by the State Council of China in 2006 followed the suit of DMCA's model in providing safe harbors for ISPs. However, the DMCA's model is like a double-edged sword. On the one hand, some provisions in DMCA helped China in cracking down on the piracy in internet. On the other hand, some other provisions in DMCA created new problems. I think it's a good time to review the good side and the bad side of the DMCA's influence on China and draw some lessons from both countries' experience. Now, first of all, I would like to give an example of the good influence of DMCA on China. The DMCA provides that one of the conditions for an ISP to be exempted from copyright liability is that it is not aware of facts or circumstances from which the infringement is apparent. The Senate report described this provision as the red flag test. It says that if the infringement is very obvious to the ISP should take actions to remove the infringing content or block the access to it, or else it will lose the limitation on its liability. The China's legislation used a similar language. It says that the ISP will not enjoy the exemption from liability if it has reasonable grounds to know that the uploaded works are infringing, but failed to take action. Many Chinese judges think that this provision is equivalent to the red flag test in DMCA and applied the test in various situations. In my opinion, the judges in China take the red flag test even much more seriously than US judges. This is because, unlike copyright infringement in China, it's much more diverse and complex. In many cases, when copyright owners bring lawsuit against the notorious websites where tens of thousands of infringing pop music and movies are shared, the ISPs always argue that they do not know. And they said that their only obligation is to remove the infringing content after they received the notice from the copyright owner. On that background, the red flag test becomes a very powerful weapon in China to stop the infringement and hold the bad faith ISP is liable for contributory infringement. This is the first case in China where the corporate owner sued the ISP for contributory infringement without sending a notice beforehand. The website concerned is something like the Pirate Bay in Sweden. Users uploaded a large number of BitTorrent seed files of movies with the posters and the detailed descriptions, and all the information is on the home page of the website. The court said that the infringing nature of the BitTorrent files of movies is very obvious and is visible to the ISP. So the ISP should have known that the movies concerned are shared without permission. So the court said that the ISP should be held liable for the contributory infringement. This case is a good example of the red flag test playing a significant and active role in combating the ISP's outreach policy. So this is the good side of the influence of the DMCA on China. I skip some slides to save time. But there's also some bad influence of the DMCA on China. In DMCA, another condition for an ISP to be exempted from the liability is that the ISP does not receive a financial benefit directly attributable to the infringing activity when the ISP has the right and ability to control the infringing activity. Apparently, this provision incorporates the long-established vicarious liability standard under the common law. Nevertheless, how to apply the vicarious liability in the digital age, how to determine that an ISP has the right and knowledge. These issues have not yet been settled 14 years in the United States after the passage of the DMCA. As a result, there are plenty of cases where a U.S. court held that the ISP are liable for both contributory infringement and vicarious infringement. But I'm not aware of a single case here in the United States where a court only held an ISP vicarious liable, but refused to hold the ISP liable for the contributory infringement. The legal uncertainty concerning the vicarious liability standard in the DMCA unfortunately adversely affects the judicial practice in China. The Chinese legislation incorporates at least a part of vicarious liability in providing that an ISP will not enjoy the exemption of liability if it gains direct benefit from the infringing content uploaded by its users. And the Chinese courts are grappling with the standard of vicarious liability, but neither the DMCA nor the judicial practice in the United States offer any valuable reference. In recent cases between the Chinese authors and Apple, Chinese authors claimed that their books were shared on App Store as paid applications, and they sued Apple for contributory infringement. The red flag test could not be applied here because there's no evidence to show that Apple is aware of the infringement of its users. But as we all know, for the paid applications, Apple received a percentage of the payment. Should Apple be held liable for the user's infringement since Apple directly get benefit from the paid applications? The court in China gave the affirmative answer. It says that Apple strongly controls the App Store and gained substantial direct economic benefit from the payment of the paid applications. Given the fact that there are tens of thousands of paid applications available on Apple Store, and only a small number of them are infringing, Apple might have a very bad time in coming days. It seems that the only possible and effective way for Apple to avoid vicarious liability is the active monitoring of its service. But Apple has nothing to complain about in China. since the provision on vicarious liability could be traced back to the DMCA. So to conclude, there might be some lessons to learn both for China and the United States. On the one hand, when China transplants a law from a foreign country, it should pay much more attention to the unique legal tradition and background from which a foreign law arises. For instance, there's no general notion of vicarious liability in China's civil law. The incorporation of the vicarious liability in the corporate regulation lacks the firm foundation. On the other hand, the upper case in China mirrors the ambiguity of the vicarious liability in DMCA and calls for rethinking of the applicability of vicarious liability in the digital age. In a word, the lessons are equally important to Chinese legislators and the US legislators. Thank you.
大家早上好。因为我注意到今天我们在屋里呢有很多来自中国的嘉宾和听众，所以呢，请允许我用中文来完成这个演讲。因为刚才在座的各位演讲者呢，对于这个中介责任从法律规定上，还有一些案例上都进行了很深入的分析。那在这里呢，我就不再班门弄斧了。那么我更想讲的呢，是从介绍微软在最近几年打击网络盗版方面的经验，以及通过这些活动我们所掌握的第一手资料，来阐述一下我们对于解决网络盗版问题的一些想法。因为毕竟我们讨论这个中介责任的这个一个主要目的，还是为了在鼓励和促进这个网络技术和网络服务发展的同时，能够确保网络服务产业和内容产业都能够健康的发展，能够减少一些由于技术带来的一些可能盗版传播更快和传播范围更广这样的一些负面影响。所以这个我想呢，我们可以从更广阔的方面来看这个问题。那么在我们在讨论软件这个盗版的时候，我们首先看一下这个网络盗版的情况。那么根据 IDC 大概在2个月之前发布的最新的研究的成果呢，对于用户来讲，现在网络已经成为获取盗版软件最主要的一个渠道。而且呢，从原来传统的这个贩卖盗版光盘，逐步的转为通过这个下载以及传播这个非法传播密钥，或者也就是俗称的激活码这样的一个情况。中国的情况呢，根据这个研究的情况呢，稍微有一点点区别，就在于对于很多用户也是通过网络获取盗版软件，但是很多的中国用户第一次获取盗版软件呢，是在购买新计算机的时候，计算机的销售商为他们安装的这些盗版软件，其中86%的个人消费者和22%的企业 IT 管理人员说，他们在购买新计算机的时候，销售商就已经为他们安装了盗版软件。当然，这些安装者他们获取盗版软件的主要来源也是通过网络。另外呢，由于现在正版软件的发行模式这几年也发生了很实质性的变化，从传统的预装和这个盗版和传统预装和光盘的发行，逐步转为正版软件的网络发行。那么网络盗版的形态也发生了变化，从传统的下载这个完整的盗版的版本，转为来非法这个传播或者售卖激活码。因为用户已经可以直接从很多这个软件企业的官方网站或者授权网站直接来下载软件，那么他们唯一所需要就是一个能够打开这个软件进行使用的钥匙，也就是这个所谓的激活码 key。那么怎么样来解决这个问题？虽然我们今天的主题是讨论这个中介的责任，但是我个人觉得，通过我们的经验来讲，最有效的办法其实是在一个比较设计完善的一个法律框架和一个完善的执法体系下，能够促进，特别是这4方的一个合作：权利人、中介、执法机关还有用户。因为这4方缺少一个， 可能都很难取得实质性效果。而且如果这4方之间只是互相的抱怨跟指责的话，我们是没有办法解决这些问题的。所以必须要进行合作。那么我们在谈论这几年，我也参加很多会议，感觉这个中介的责任已经成为这个版权发展的大家一个非常关注的点。但是我想强调的是，对于权利来讲，首先我们还是要考虑怎么样去打击盗版的源头，因为毕竟这是保护自己权利的根本。因为虽然我们通过网络上看到的所传播的很多的信息可能都是侵权，但是如果你真的去分析它们，你会发现大部分的这个盗版内容是来自于一些职业犯罪团伙。这也是为什么我们要投入更多的资源去打击这些源头。这里呢，我就不做案件的详细的介绍，但是通过这些情况，我们看到实际上在中国，我们在处理这个盗版微软软件的时候，我们发现是很多盗版团伙在从事这样的行为。特别是我举一个例子，像上海的萝卜花园案里头，它的表面上是一个正版的服务，它做这个导航网站，然后通过网络广告，它1年的营收大概有1个多亿人民币。但是背后它是实际上设立了5个盗版网站，以及大概在20多个省市有1000多个下载点。那么它是通过制作和网络传播盗版的微软软件来获取流量，以支持它的这个导航网站和广告的服务来获利的。那么实际上，如果你不去打它这个源头的话，那么这些版本不管是它自己传播，还是很多网民通过 P2P 的方式，还是其他方式去传播，它永远会在那儿去存在。不管你 take down 多少，它还会继续再回来。另外呢，而且我们也会发现，这些网络盗版的这个团伙呢，并不只是像大家想的，可能几个，比如说我们 IT 的行业的高材生，说出于个人兴趣来设立这样的情况来进行传播盗版，发现他们确实是职业犯罪团伙。尤其是在一个案件中，当时这个主犯，他除了是他有服务器、有电脑以外，他开着豪车，有保时捷，有奥迪，他手里还有3把枪，所以实际上这个是很明显的证明了，很多都是一种非常职业的犯罪团伙。针对如果大家熟悉中国网络购物的话，这个淘宝基本上相当于在这个美国的 eBay 跟 Amazon， 就是它实际上是中国最大的电子商务网站。那么他们顶上有很多贩卖这个盗版的产品的这个情况。那么我们呢也跟公安机关配合，那么这几年采取了一些刑事手段，打击了一些比较大的在通过淘宝来贩卖这个盗版产品的这个团伙，也取得了很大的成功。那么它导致的一个实际情况来讲，通过这些行为，一方面我们打击的源头，另外一方面也向我们的这些网络中介证明，实际上网络盗版是一种职业的有组织犯罪。那么我们必须要合作来解决这项问题，否则的话，可能你的行为就在帮助这个网络犯罪行为。那么我们得到了更积极的回应。在以前，比如说我们要给一个网站去发一个通知的话，可能他会说你要给我授权书，你要给我各种各样的证明材料，甚至说你必须把这个材料要寄给我，然后我才能去帮你做这个事情。但是在通过这几轮的打击之后，我们现在发现情况发生很大的变化。我现在基本上98%的这个情况下，我只要发一封 email， 这个网站就会很快把它拿掉。那么以前可能他拿掉的，他可能会我不配合你，或者他说我可能花1周或甚至更长时间才能帮你做这个事情。但现在基本上73%的网站能够在24小时之内，根据我们的通知把这个事情移除掉，把这侵权的内容移除掉。而且另外发现一个非常有趣的现象，之前很多这些盗版的网站，他们的服务器都在中国，但是通过这些打击行为，很多这个网站它为了规避法律责任，已经把它的服务器移到境外。特别是对一些现在目前仍然存在的相对比较大的网站，这数据我没有放在这里，大概前30位的网站，基本上100%都已经把它服务器放在境外。很有意思的事情是这样，有相当一部分的服务器是放到了美国。可能他会觉得由于它是中文的网站，但是服务器在美国，可能被执法机关打击的这个可能性会更小。另外，在淘宝上也是一样，经过我们这样的这个努力，同时我们非常积极发通知从淘宝上去移除这些信息。那么我们经过大概将近2年的活动，那么淘宝上这个贩卖盗版软件的信息已经下降了70%多。另外我们也不光是在局限于一个境内，我们也做这个全球的这种执法。而且这里我想强调，当我们讨论中介的时候，可能很多大家在考虑的是一些网络服务商，但是从我们在工作的角度来讲，我们考虑的这个中介是更加宽泛的。它不仅是网络服务的提供商，而且还包括比如说网络支付的工具，甚至一些银行和一些金融机构，那么他们在这里头能帮助我们起到什么作用？这个案件的具体的内容呢，我就不讲，因为花时间会太多。但这里头呢，实际上我们除了在跟很多网站域名服务商合作，去把这些侵权的网站或者侵权信息移除的基础上呢，我们还跟网络支付商，特别像 Mastercard， 还有这个 PayPal 来合作，把一些他们的这个用于支付的这个 这个收取这些买盗版的这个钱的这些账户进行关停，那么起到了很好的效果。另外呢，在用户这块呢，一直是一个长期以来的一个矛盾，因为很多用户会说，盗版软件对我没有什么危害啊，所以我为什么要支持你做这样的事情呢？所以在这方面呢，我们也做了一些很深入的分析。根据这是 IDC 的一个研究，大概全球在使用盗版软件的计算机上，有1/3是感染了这个病毒或者恶意软件。在中国呢，由于使用盗版软件的种类和范围种类更多、范围更广，所以有78%的电脑是有感染的风险。另外，从这个感染的风险的这里头，种类来讲，大概有78%是属于这种间谍软件，那么还有36%是感染了这种木马的病毒，它也是导致这僵尸网络以及其他的这种各种网络安全风险比较泛滥的这种行为。这个呢，不只是一个非常宽泛的分析，其实呢是非常现实。就像我刚才提到的一个上海的萝卜花园的这个案子里头，我们对于执法机关提供给我们的他们所获取的那些版本进行了分析，发现所有的版本都感染了这个病毒或者恶意软件，其中94%是这个木马的程序，6%是这种后门的程序，实际上是有非常大的风险。如果你使用这样的软件的话，那么就意味着不仅是说你这个没有享受到正版软件的服务，而且你的个人信息和隐私有很大的这个风险。所以在这种情况下，我们的想法是觉得，法律框架除了说我们界定清楚每一方你应该承担的责任和权利和义务以外，更主要的是通过一个科学的法律制度的设计，以及整个有效执法体系的建设，能够促进这个各方能够真正的去合作，互相理解、互相合作，这样才能真正起到控制网络盗版这样的这个实际的效果。但是同时，我们也看到，实际上很多法律的发展都是在这各方的这个利益相关方，他们不断的在合作，所探索出新的一些方式的时候，我们然后再通过法律去固定下来。刚才我们加拿大的这位教授已经讲说得很清楚了，很多时候都是产业界在先探索出好的办法，再通过法律固定进行推而广之。所以在这个过程中，我们是需要这样一个良好的一个互动的。那我的演讲就到此，谢谢大家。
Good morning, everyone. I'd like to take this opportunity to thank the organizer, the sponsor, and Professor Goldstein for giving me this opportunity to share my opinions. Let's see. I want to have a cover page. This one, right? Yes, that's right. My topic today is copyright liability for UGC. The concept of user-generated content has been around for a long time, but the service that promotes such content creation has only been fostered since 2005, around the time of the taking off of Web 2.0. The other panelists have already spoken about different aspects of ISP with regard to Canada, US, and China, and also the copyright's importance with regard to directing the efforts of innovation. So I would like to take this opportunity to introduce Baidu's actual practice in this area and offer a couple of thoughts. Baidu is mostly well known for its search engine service in the China market, but with the mission of providing the best way for people to find what they're looking for online, we also have gradually, provided quite some services with regard to UGC. Some of the prominent examples include Tieba, which got online in 2003, which provides an online platform in which people sharing similar interests can share contents with each other. Currently, there are about 4.5 million mini gathering grounds. We call them Tieba, and also the daily exchanging topics is exceeding 100 million. So there's quite some, user-generated content providing these services. Other prominent UGC services provided by Baidu include Baiku, which is an online Chinese encyclopedia, and Wenku, which is an online service for users to share their contents. As you can tell, through this UGC services, quite some users are, generating contents and also unavoidably, creating copyright liabilities for the company. So to fulfill the responsibility that comes up with such liability, Baidu has early on implemented notice and takedown procedure, which was thoroughly discussed by by the other panelists here. That's compatible with the DMCA requirements, even before such requirements adapted by the Chinese legal system. But we did not really stop here, because for business such as UGC, the interests of the company providing such service is actually in line with the public policies here, which is balancing the rights of the copyright owner, which happens to be the one who generates such contents, and also the consumer of such content, which is the web user of such services. Because we have an interest to keep this balance, we actually actively explore different innovative mechanisms to provide the benefit of, that essentially line up everybody's interests here. For example, some of the innovations can be categorized as procedural innovations. What we do is we, essentially just constantly optimize our internal processes to timely process the large volumes of notices generated by such services, and then, just such that we can just give them a timely response for that. And also, we have implemented an expedited pathway. Essentially, it's equivalent to the express lanes in the airport if you just happen to be late for travel, and issue certificates for well-established right owners, and waive certain procedural requirements to facilitate them to more conveniently enforce their rights. We have also implemented mechanisms to essentially facilitate efficient management of UGC creators. For example, we provide a mechanism to register the copyright for copyright protections for those prominent UGC creators, and to essentially encourage them to generate more novel contents. And on top of that, we also use other mechanisms such like blacklist to discourage the kind of copyright infringement activities. But procedure innovations alone has a limit because of the enormous amount of UGC generated every day. We have to rely on technical innovations to do most part of the work. So we have developed and continuously optimized the content fingerprint technologies to essentially recognize the kind of a suspect of copyright infringement materials, and then deal with them accordingly. Another part is, as part of the effort to provide users with high quality and authorized contents, we also cooperate with essentially the associations of right owners. One, as you may know, a lot of times the content that is created by UGC owners may well infringe other people's rights. For example, some UGC owners may well just create a song of their own and then upload it to certain websites. She may well use the lyrics of other people's have rights in. So we essentially try to negotiate with such organizations such as the Chinese Authors Guild to get rights on this. And also another example is we have a contract with the Music Copyright Society of China, such that we have rights in their members' lyrics. And then we provide information regarding the songs and musics that's related to their rights. And then we get essentially we pay them for the uses, while maintaining the rights for the UGC creators of the service. And on top of that, we also have innovations with regard to the business models, because after all, just in order for a service to thrive, the business model has to be in line too. So, for example, we also have an open platform for reading materials, which essentially try to give the content owners a new channel of generating revenues, And also, we also give the readers and the users of this service flexible mechanism of making payments to consume such contents. Okay, so one thought I have with regard to this is lots of times, especially in the user-generated content field, because the interest of the business is in line with the policy creators here, it is more beneficial to have a rather less restrictive legal platforms. This way, the business can use its own activities, creativities, to try to generate some kind of innovations. Like, for example, the mechanisms I mentioned just now, procedural, technology, cooperation, and business models. This way, the more space that it can maneuver around within the legal framework, the more choices the business can have. As a result, the services that foster such services can generate more creative contents for this society, for the human beings. That's essentially my presentation here. And thank you very much, and I'm looking forward to your questions. Thank you.
Well, we have 15 minutes for questions. I invite you, there are microphones in each aisle. If there are questions, please. Please.
Okay. Thank you very much for the presentations. This question might be a little bit of digression. Yesterday, we heard about several Chinese panelists talk about the increasingly importance of court decisions in facing maybe privacy issues in the digital age. But today, we also hear about, like in common law countries, there are codifications on the, for example, the copyright issues, the Copyright Modernization Act. What a beautiful name. So my question would be, what's the advantage and disadvantage of two kinds of legal remedies, the traditional common law style common law torts and the civil law style codifications, and particularly in the digital age? Thank you very much.
Good. That's a very interesting question. The different impact of copyright and civil law systems on resolving issues here of copyright liability. Canada is the perfect example because it has both a common law and a civil law approach to copyright. China, of course, has a civil law. The US has a common law approach. Any of our panelists want to reflect on that? Whether it's made a difference.
I'll take a quick stab at that question. I think there is not nearly as much difference as legal scholars would like to believe. Obviously, at Google, we operate in countries that have both civil law and common law systems. And even in the United States, for example, you have torts like defamation, for example, that are much more common law in spirit, and copyright, which of course is much more codified. And what we've found in virtually every jurisdiction, I think, is that the legal scholars' view that there is a huge difference is overstated. So, for example, in Germany, where it is very much a civil law tradition, we nevertheless find German courts, as they try to apply the statutory language to new circumstances, effectively using the same common law modes of thinking and looking to prior decisions by other courts confronting similar things. In other words, they're acting in exactly a common law way to fill in the gaps between the language of the civil code and the changing circumstances they see in front of them. And similarly, in the United States, of course, I think the DMCA safe harbors are a fantastic example of the US legislature responding with a codification approach to what previously intermediary liability under copyright in the United States is really very much like a common law approach, contributory infringement, vicarious liability, inducement. All of those doctrines arose as a matter of judge-made law. They were not codified. Even today, they are still not codified. And yet, the leading legal rules for online service providers today are the DMCA safe harbors, which are very detailed codification. So I think it is you should not make too much of the supposed difference. In both systems, you have both modes of thinking. They tend to coexist.
Let me add one quick point. At Stanford Law School, we have a very important China leading case project. This project is based on the premises that the Supreme Court of China declares those leading cases should have reference value in lower court decisions. So you can regard this kind of system as a Chinese version of stare decisis, the precedent system. So nowadays, those important copyright and other internet decisions become more and more influenced in subsequent court decisions. Thanks.
Yeah, if I could just respond to, I agree with what Fred was saying, that indeed one thing that I've noticed is that there's more and more convergence between the civilian and common law traditions, and there's cross-pollination with some of the key doctrines and terms that we discuss. One thing that I do see, Canada seems to be a really perfect petri dish as an example, because of course it has a bi-juridical tradition. It has both the civilian and common law within the same country. So we have Quebec's tradition and then the rest of Canada. And you see this really constantly played out, like all the years that it took for us to put the Copyright Act together. You saw in every testimony for Parliament, Quebec's sort of more authors' rights-based voices, and even up in the slide I had there, the authors' rights groups were not in favor of the notice and notice regime. So you see that pronounced, and the government always tries to reconcile those tensions, which, while practically speaking maybe come to be the same in the end, they really play out in the debates with the stakeholder views. So it is, the tensions are there, but practically speaking, we don't see it play out in the laws.
I would like to give an example to explain the different approaches adopted by the common law countries and the civil law countries. I think the safe harbor provisions are the typical common law approaches to the intermediary's liability. Because safe harbors means that intermediaries are exempted from liabilities. When China adopted the same mechanism in the copyright regulation, at least at the first beginning, judges in China are confused. They asked what kind of liability are the intermediaries exempted from if they are not infringers at the first place. For instance, in China tort law, we never think that telephone companies who only provide conduct for telecommunications are the infringer. If they are not infringers at the first time, what kind of liability they are exempt from? So in civil law countries, including China, traditionally the legal techniques we used is that on certain conditions, somebody should be held liable. We never used the legal mechanism in providing legal rules saying that on certain conditions, someone is exempted from liability. So I think that is the key difference.
Thank you very much. The topic is about the safe harbor for copyright, DMCA. But I would like to press the envelope further. Let's suppose we reproduce or substitute copyright with other kinds of right, like defamation, child pornography, hatred speeches. Can we apply the same principle of safe harbor to the ISP? Or what kind of liability the ISP should play? Should we have a private police function imposed on the ISP? Thank you very much.
just to pick on the first question, but to open this to the panelists, I think what you have in mind is a system like the e-commerce directive in Europe, in the European Union, which is a so-called horizontal directive for safe harbors that incorporates not only copyright, but defamation, trademark, and other forms of liability. It would be good to hear about political experience with that, legislative experience in China, in Canada, in any thoughts in the US from our panelists? Anyone have?
Well, I will just, Paul is exactly right that the European approach is more horizontal in nature. In the United States, for those who don't know, we also have a safe harbor regime for many of those other forms of intermediary legal liability in what we call the Communications Decency Act, which in essence is, I would say, more than a safe harbor. It is actually an immunity from liability. So, for example, for defamation in the United States, an intermediary who is merely republishing something authored by someone else has no obligation to remove that content. There's no, it is more like the circumstance that was just described, that no one would think that a telephone company would be liable in the first place. And that's more the spirit. So there are different approaches, and I would simply say that no matter which approach a country might adopt, the important question is always to ask, what impact will this have on innovation, particularly for smaller startup companies? Because often the question that you ask, often people look at it and they say, well, we should ask, well, what could this, what could Baidu do? What could Google do? What could Microsoft do? And certainly that's a perfectly fine question to ask. But you must remember that we all hope, I think, that 10 years from now, we will be talking about companies whose names we today have never heard of, because that's what we want. We want more innovation, more new entrants into the market. So whatever the intermediary regime, no matter how broad you want to apply it, you should ask, what impact will it have on small innovators today?
So under Chinese law, the safe harbors are specified only under the regulation concerning the right of network communication over the information network. That means only copyright law provides specific safe harbors for ISPs. There's a very general provision under the tort liability law, but that provision does not include any safe harbors or any kind of liabilities, for example, trademark or other kind of tort liabilities. But I would like to say, in practice, many Chinese courts, if they hear a trademark case, they will look at similar copyright cases. They will apply similar principles in those cases, even without specific statutory guidance. And to just give you one quick example, there's a quite famous case, Puma versus Alibaba, a few years ago. And Alibaba essentially applied a variant-like program, follow the eBay example. And as the case in the United States, like Tiffany versus eBay, right? Alibaba was held not liable for trademark infringement. So in practice, the difference is not really that important. Thank you.
Hello, I just want to supplement on that. I agree with Jerry. Actually, in China, under the general tort liability law, there's already provision where actually right holders can rely on to claim their rights based on like trademark, trade secret, and others, even for privacy. For example, when we take down those infringing products from Taobao and some other auction sites in China, we basically, claiming our trademark, rights instead of copyright, because it's very hard for them to go through all the copyright registration documents, other things, because it's easier for them to identify the trademark used by those sellers who listed those offering on their websites. And also, I know many of those right holders, they also send notices to Baidu to take down those documents published in Wenku, but for infringing their trade secrets. So that's basically some examples, how we do the takedowns for the other IP areas.
Thank you, Yunxuan, for identifying the practice. We actually use, again, using trade secret practices. I just want to point out that one thing I think the restriction should be applied is essentially lining up the interests of different parties. So taking down procedure is one way to line up interests. There are other ways. But as long as the interests are lined up, I think the companies will use their, their internal mechanism to make sure it works. Okay.
I would also like to give some explanations to the difference between the legal concept of tort and infringement. At least in common law countries, the concept of tort is different from infringement. If a person is going to be held liable for defamation, the person must have the intention of the negligence. But the copyright liability is a strict liability. A person does not have to have the intention or negligence to infringe to be held liable for copyright infringement. So when we are talking about safe harbors for intermediaries, we are talking about to shelter ISPs from the copyright liability. So that is a key difference from the defamation of the internet and copyright infringement in the internet.
Good. Thank you. If I could just offer a footnote to Professor Liu's point and to Fred von Lohman's point. It's interesting to observe in the United States that although safe harbors are limited to copyright, a number of internet companies, very smart internet companies, have privately within the company adopted the identical form of notice and takedown procedure for trademark, recognizing that a court, although saying there's no law that exonerates you from this, would view the safe harbors as a form of intellectual property best practice, so that this private incorporation of this technique, in the case of trademark, not covered by the law, has proved to be an effective mechanism. The last point, and this is the footnote to Fred von Lohman's, is I think we're all here sensitive to his twice mentioned theme of being sure to have systems that protect small internet service providers. In the interest of balance in the Canadian style, I would suggest that it's also important to look at the plight of small copyright owners under these systems. Not every copyright owner, not every author, artist, musician, or filmmaker is in the position of, say, Universal Music Group and able to monitor all of the activities on YouTube and devote considerable resources to that. Be concerned as well in designing these systems for the plight, the concern, the context of the small individual creative copyright owner. With that, we are a little bit past our 10:30 break time. I hope that our panelists will be available for questions during the tea break. Thank you very much for what I found a very, very enlightening set of discussions, and thank you all for your attention.